Good morning, everyone. How are you? Welcome to another UN Women, Nano Women Advancement Masterclass this morning. How's everyone doing? You can let us know in the chat. Let us know how you are. I think actually I would love to hear where people are from. Over December, we had lots of people saying that they were on holiday, but I would love to hear where you're coming from in the UAE, or if you're joining us from outside of the UAE still as well. So beautiful to see everybody here today. Our first masterclass of 2022 and super important masterclass as well. So we've got Abu Dhabi, Dubai. I always like to see if we can get every emirate as part of this as well. We've got someone who's in Germany. Good morning, Lena, in Germany. And let's see. It's from Sharjah. Oh, we've got a few people who are doing quarantine still. Someone's in Croatia at the moment. Lots of Abu Dhabi. Oh, Louise is over in Dubai, Media City. Good morning, Media City. Al-Aware. I still want to see if we can get someone from Ras Al Khaimah, Fujairah. It'd be great to see the Northern Emirates on here as well. I love all of our Dubai people are getting very detailed about exactly where they are in Dubai. Got people in Barsha, DIFC, all right. Excellent. Well, we're just going to give it a couple more minutes. Oh, we've got someone from Bahrain as well. And so we're just going to give everyone a few more minutes to get settled, and then we're going to jump right in. I was saying to Sarah this morning as well that this is like one of my favorite topics. I find as a business owner as well that it's fun to do like all the marketing, branding, social media stuff, but I actually really love I really love like the very serious businessy system structures, legal areas as well, because it's so important that we get it right. And I've seen the presentation that Sarah has today lined up for you, and it's just pure gold of everything that you need as a small business owner to be able to legally run your business from a UAE Labour Law perspective. So that's brilliant that we have that. Okay, I'm going to, Maya, my colleague at UN Women, is going to be watching and letting everybody in. I am just going to jump on here and do a quick introduction because there's a lot that we need to get through this morning. Just to let you know, I am, for those of you who don't know me, I'm Jen Blandos. I am an entrepreneurship consultant and advisor with UN Women. And I am going to be your host for today with Sarah, who is going to be our expert presenter for the day. I'm going to let Sarah introduce herself in a second, but I'm just going to take you through. As always, we have a little bit of housekeeping and some UN Women updates that I wanted to share with you. As always as well, I always have a little slide that I love to show you just with how you can reach everybody on social media. So here are the tags for LinkedIn and Instagram. Also, UN Women is also on Twitter. Anywhere that you are on social media, you'll be able to find UN Women, you'll be able to find NAMA Women Advancement. And also as well, we've got Sarah's details there as well. Sarah loves LinkedIn. So those of you who are on LinkedIn, that's where you're going to find Sarah as well. And a couple of announcements that we have for things coming up. First one, a number of you, especially since you're already on the mailing list, that you will have received an email about a 16-week accelerator that we're having for new businesses. Now, this probably is not going to be relevant for all of you, especially if you're joining this session, you most likely have an established business and you have people who are working for you. And so it might not be so relevant for you, but if you have any contacts or friends who are entrepreneurs that you think that this would benefit, it's a 16-week accelerator that's really designed to help women who have a business idea or maybe have had a business for under a year and are kind of stuck and want to understand how they can really get that business going. And what we really wanted to do with this accelerator is make it so it doesn't matter what industry you come in, We're not looking for tech unicorns. We're not looking for specific types of businesses. The aim of this accelerator is to really help women set up and structure their businesses in a way that's really going to get them to having a proper business. Because as we know as entrepreneurs, the first couple of years are quite critical in a business, and we're really hoping with this accelerator that we'll be able to help women have that foundation right in the beginning. The other one that I would like to tell you about is UN Women's Women-Owned Business Directory. And this, if you have a UAE licensed business and you're women-owned, and I believe that probably most of you here today are a woman-owned business, it would be brilliant if you would be able to submit your details, because UN Women is actively speaking with heads of procurement for a number of different government entities, organizations, and companies that are based here in the UAE. And what they want to do is they want to be able to introduce women-owned businesses to these companies to help you grow your business. And 100% they're doing this. I was part of an event last week in Expo where we had a meeting with a number of heads of procurement, and a lot of the heads of procurement were saying, we would love to buy more from women-owned businesses, but we don't know how to find them. So Hiba, who a number of you know from UN Women, put up her hand and said, well, we have a woman-owned business directory. So please do submit your details for this, because then that will allow us to share those details as well. And those of you that are part of the UN Women mailing list, UN Women is also trying to organize a number of events to help you get more contacts with procurement people. So for example, this week at Expo, we're having our first Meet the Buyer event. Submissions for that are already closed, but we will be doing other ones as well before Expo closes and throughout the year. Okay, so Maya has put in the chat box there the link to the accelerator program, the link to the women-owned business directory, and she'll pop them in the chat a few times again as well. So if you have any questions you want to know about that, just pop a question in the chat. So we're going to kick off for our session with Sarah today. Now, a couple of other things, and I think most of you have been through these sessions before, but I would like to ask you, because we are over 100 people and I want all of you to be able to get the best possible experience from this. We love making it interactive, but if we have people unmute themselves, it's going to make it quite difficult for Sarah to get through all of the content. So if you have a question, can you pop your question in the chat box, and myself and Maya will be looking through the questions and we'll go and pull them up. And you might not have your question answered immediately, because I know what the presentation looks like. So I'm going to be grouping them for Sarah, and we'll cover them at different points throughout the presentation. So it will make it easier that she'll be able to share that information with you.
So I think beyond that, if you want to give a push or a call to Christian, that would be
sorry
helpful.
Somebody, Maya, who is and that is why please keep yourselves muted, please. Thank you. Right, so that's what we need to do. One last thing about the chat box that I can please ask you as well is, please do not write promotional selling notices about your business, because these are non-promotional sessions. We are here to learn. We are here to collaborate. We're not here to sell our services to other businesses. So if one of the admin team sees that, they'll be removing people directly from the meeting and you won't be allowed to come back in. So if I could please ask you just to do that, use the chat box, have fun. And now I would like to ask Sarah to take the floor and introduce herself. And Sarah, I'm going to take myself off the screen and I will be available if you need anything, and I will come back with questions as we go on.
Okay, fantastic. Well, good morning, everyone, and thank you so much for joining me and Jen this morning, and Maya as well. And for those in Germany, that's a very early start, and Croatia, I think, as well. So kudos to you for getting up this early in the morning to learn about labour law updates. So my name is Sarah Brooks. I've been working in human resources for 20 plus years. I've been working for over 25 years in hospitality as a manager and as a leader. And I've spent the last 15 and a half years working in the GCC. I have experience working across Qatar, Kuwait, Oman, Saudi, Bahrain, Abu Dhabi, Dubai, and various other little bits and pieces here and there. So one of my passions is human resources, quite obviously, but also doing it right and remembering to be human around human resources. I know that sounds like an odd thing to say, but many companies here, especially some of the more long-standing ones, tend to have a more administrative approach to human resources. And I think that's somewhat detrimental to the business. So one of the missions for today is to go through the labour law. And what I'd just like to understand a little bit from you is, how confident are you in your knowledge of the labour law? Now, I'm sure all of you are very familiar with the current labour law, which we have 8 days and counting until it's changed. But if you could just give me an idea of where we sit in terms of your knowledge of the changes for the labour law that's coming up, that would be great. Okay, so we have some good results coming through here, with the majority of people having some knowledge to very good knowledge, which is great. And like I said, the labour law that we have at the moment has been in place for a good number of years. There's a lot of information around about it, but this is more about the changes that are going to happen with the new labour law. Okay, so everyone has some knowledge, which is great, and hopefully we can build on that. As Jen has said, please ask whatever questions you have. I will share the results for you. There we go. So you can see that. Please think about the questions that you need answering. Think about any of the queries that you've had over the months and since the announcement. Okay, and give me 30 seconds here. 1 second. I've got stuff. Sometimes I hate Zoom. There we go. Okay, so what we're going to look at is a very, very brief overview of the labour law, and then what your requirements are to, as an employer within applying the labour law to your business, and the new working rules. Now, I've picked 4 of the key areas. Obviously, the rules that we have, there are a lot of changes. There's some 70 odd pages of changes that are of new laws that are coming. So I picked the 4 sort of really key areas that most people have questions about, and then tips and best practice. My aim is to go through this and to spend about 45 minutes to an hour discussing this. I want to give as much time as possible for you to ask questions. And just as a caveat on the questions, if I don't have an answer, I will find out an answer and I will come back to you through the channels that we have, okay? To be clear, as I've mentioned, I'm an HR manager, an HR professional. I'm not a lawyer by any stretch of the imagination. I do have a fairly good knowledge and understanding of legal terminology and how the labour law is written, but it's worth noting and understanding at this point that the laws, as we know in the UAE, the prevailing language is Arabic and the legal language is Arabic. So all legislation is issued in Arabic, and in the event of any queries of any mistranslation, misunderstanding, whatever is written in Arabic will prevail. Okay, the information that I have and that I'll be sharing with you has come from various documentation, various webinars that I've attended, including those presented by legal firms, to validate and understand my knowledge and expertise on the new laws and the new information. Okay, it's also worth noting that there are a lot of questions still yet to be answered. I have endeavoured to get the information from the ministry themselves, and unfortunately their response is that it needs to be and it will be issued after the 2nd of February. So for some things, we are literally just going to have to wait. There's a number of references across a number of articles within the new labour law, which states that there is a document called the Executive Regulations. And it's mentioned that the executive regulations will give details, all this 1, 2, 3 will be defined within the executive regulations. So I'm anticipating that there will be an additional document of details that will come out that will link into, or sort of jigsaw fit into, the existing documentation we have about the new labour law. The other elements that there are is that there are some comments with regards to decisions made by decree from various ministers. This relates to specific positions, levels of seniority, to contract types, various things around leave calculations, salary and things like this, minimum wage, all of this sort of stuff. This is all going to be discussed, or has been hopefully been discussed over the last couple of months since the announcement, and then we should get more information coming soon, next week, maybe the week after. Okay, I don't think we're going to be inundated. I'm hoping sincerely that we're able to get at least 1 or 2 more documents, or a bit more depth around what we've been given already, but it does mean that we do have some questions that are still a bit vague. Okay. So what I've tried to concentrate on is the stuff that we know absolutely. Okay, so the labour law, as we know, was set up originally in 1980, and it was to provide regulation for the labour market. Now, obviously, between 1980 and 2022, there's a big gap in terms of time frame. And globally, the employment market has changed an awful lot, and locally, the employment market has changed an awful lot. The different types of industries and business, the expatriate nationalities, the locals that are joining us in the workplace, it's changed dramatically, that the labour law needs to be reviewed. Now, over the years, there has been revision with amendments coming out more recently in 2017, 2018, but this now is the first major overhaul that has happened of the UAE labour law since its inception. One of the key things to note with this new labour law is that it does cover all businesses and all company types. Previously, and it is the UAE labour law. It is not the labour law for the Emirate of Dubai or for the Emirate of Abu Dhabi. It is for the whole of the UAE, which means it is applicable in all Emirates. For the different types of companies, most of you will be aware that we have the mainland trade licenses and companies that run under mainland visas. We also have the free zones, and we have a number of different free zones. For example, free zones in the various Emirates, but we also have free zones by location within Dubai. For example, you would have TCOM, DMCC, DIFC, and all kinds of other acronyms as well. This labour law will cover all of those free zones, except on the occasion that the free zone has its own legislation, for example, DIFC. Most of the free zones do have some element of employment law legislation at the moment, which does follow the existing law, so it's not going to be too much of a transition. But what this means for the employee and for the employer is there's a little bit more clarity. For the employee, it means they have the opportunity to actually voice any complaints and concerns they might have. They have a place to go, which at the moment they don't. They are given advice, but they're turned away from the Ministry of Labour, unfortunately, sorry, Ministry of Human Resources, unfortunately, but that should change this year with the new legislation that's coming in, okay? So it is for all business types. Okay, so there are 6 key areas that the labour law covers. In general, okay, and we can, sorry, let's go back one. Excuse me a second whilst I play with, sometimes. There we go. Let's go back here 1 second. Apologies for that. Okay, so there are 6 key areas of the labour law, and I've kind of classified them and bunched them into sections. So we've got contracts and types of employment, and this is the full-time employment, you've got flexible, you've got part-time working, you've got condensed hours. Some of this is defined within the new labour law, some of it isn't yet, and we need to wait for more information. Contracts, as we know, it's been defined and instructed that unlimited contracts will not be in place anymore, and we will be shifting on to limited contracts, which I will come on to in a little bit later. Contract termination and end of service benefits. So this is how we can end a contract of employment with an employee, equally how they can end it with us. And then end of service benefits that are eligible for the employee and the changes around that. The various leave types, which include annual leave, maternity, paternity, and what have you. We'll come on to that shortly. Disciplinary rules, also very important. There are slight changes in that within the new labour law, not massive, but noteworthy, and we'll go through those in a moment. Then you have the regulation of working hours. Regulation of working hours, there has been a lot of discussion over this, and it's not something that I've highlighted within this presentation because of the amount of information that's been shared, what with the government changing its working week and the weekly off. So the regulations of working hours within the new labour law still state that it's 48 hours as a maximum number of hours that can be worked to be considered a full-time working week. Okay, it does not mean that somebody cannot work less than that, because absolutely, if you want your employees to work a maximum of 40 hours, then hallelujah, happy days, that is perfect. Okay, but it is a maximum of 48, and that is where anything over 48 hours for an employee automatically becomes overtime. Okay. And then you've got treatment and equality. And this is another big area that's been discussed within the labour law. Unfortunately, it's something that I haven't, we don't have a lot of information about as to how it's going to be managed and regulated. So I've not included it in this as being a key area, but it is something that we need to be aware of moving forwards. Okay. So your requirements to comply as an employer. This seems like a fairly straightforward thing, but one of the reasons that we have a labour law is to make sure that everyone who is employed across all of the UAE has a unified, fair and equal treatment. That's with regards to application of annual leave, with regards to notice periods, with regards to disciplinary processes, termination, sick leave, all of these kinds of things. It is something so that the UAE can ensure that employees are treated fairly with all of the companies that are in the country. And it gives strength to the country globally that there are such regulations in place. In many other countries in the world, for example, from my expertise and experience in the UK, companies have a minimum requirement through the law, but there is flexibility that they can add or sort of vastly increase or change the benefits accordingly. Standardized regulations for employees to abide by. This is equally important because quite often we forget that this is, the labour law is for the benefit of the employees all the time, but it also gives power to the arm of the employer. There are certain criteria in which an employee can resign from their position with no notice, for example. And if the employee does not abide by that, then they are at fault. The new legislation with regards to probation periods, there is more strict applications there for the employees to follow, which can be quite restrictive for them in the future, and will support the employers in that regard, which I think is a very positive step. And the other thing is that the Ministry of Human Resources files, so when you apply for your work permit that then goes transferred through to immigration for the residency visa, these records are linked to the trade licenses for the business. If you have complaints from an employee, they will be recorded against your trade license. If you have court hearings or anything like this, they will be recorded against the trade license. Essentially, in the future, there will be fines, potentially if you make mistakes, and they are upheld by the Ministry of Human Resources. And this is where it can affect your capacity as an employer to hire people in the future. It may be more expensive for you for visa processing. It may be that you have restricted numbers of visas. It may be that you're not actually able to apply for any visas. So it's well worth understanding the requirements, putting in place documentation procedures within your business to make sure that you comply with the legislation. If you go over and above, there is no problem at all. The concern is if you go less than and lower than, that's when the issues will come up. And it's really, really, really not worth not following the rules, so to speak, because the implications of not following the rules are very expensive. Okay, employment contracts. These are all now fixed term renewable contracts. What does this mean? The contracts are up to a maximum of 3 years in duration. Can be for 1 year, can be for 2 years, but maximum of 3 years. And they are renewable, and they are unlimited renewable. One of the concerns that I've heard raised from employees is that they don't have what I would call confidence and stability and security in employment because they don't have an unlimited contract. My response to that is that I've never ever had a fixed term contract in the time that I've been employed in the region. And I've had my position made redundant 7 times in 15.5 years. So I am not entirely convinced that having an unlimited contract is actually any more secure than having a limited term contract. There are changes to the terms around the limited term contract. The continuous service is still considered from the first date of employment. We'll come on to the changes with regards to probation period shortly, but the penalty of 45 days on resignation prior to the end of the contract for an employee has been removed, okay, or appears to have been removed from the terms, which is, from an employer's perspective, a shame, but that is why you've then got some security with your probationary period changes. I would recommend, because you can still terminate someone during the fixed term contract following disciplinary procedure and by giving them notice, but you do need to follow the disciplinary rules. So I do believe that you need to have a robust recruitment process to make sure that you've got the right person in the job in the first place, but also on the flip side, once they're employed with you, a good performance management process, which is documented to make sure that you can, if someone is not performing, you have the capacity to remove that person from your business with the least amount of financial investment possible. We currently have a 12-month grace period from the 2nd of February to transfer all existing employees that are on either unlimited contracts or pre-existing limited contracts onto the new limited contracts. What I would recommend that you do is go through all of your employees and understand, categorize between your limited contracted staff and your unlimited contracted staff. With your limited contracted staff, when is their limited contract going to expire? If it's within the next 12 months, then you don't necessarily need to do anything. If it is outside of that 12 months, then you have 2 options. You can either give an addendum to contract with regards to the updated contract terms for the new fixed term contract, or, as has been advised by the Ministry of Human Resources, you can give them notice to terminate the contract and start them either as a new employee or with continuous service. For your unlimited contracts, there has been information issued with regards to notice periods, and they are recommending and advising to give extended notice periods dependent upon how long that person has worked with your company in order to terminate an unlimited contract and to give the option to transfer onto the fixed term contract should you wish. Okay, and should the person wish to continue working with you and vice versa, which I can't believe they wouldn't want to continue working with you, but that this is the new terms with the 3 years. Now, if there are any beneficial clauses, so in some instances, you may have a clause or condition in your original contract, be it a fixed term contract or an unlimited contract, that is more beneficial to the employee than in the new fixed term contracts. The law is quite clear in saying those beneficial clauses must be carried over, so you cannot reduce it. If, for example, you give 35 days annual leave and the new, which is better than obviously what's in the labour law, then you need to continue that and carry that over as an example. Okay, it's quite straight. I say it's quite straightforward. It's not really, but the new contracts are quite straightforward. They're less complicated than previous contracts, and actually having everybody on the same structure in the business is actually going to make things a little bit more clear, I believe. Okay, so the important changes to probation. Previously, the probation notice has been that the employer is the only person who can give 24 hours notice to terminate an individual, and that that can be done without reason. Obviously, there has been research done within the Ministry of Human Resources with regards to termination processes to understand that this has actually become a bit of a problem for employees, and it does cause a little of uncertainty and unsettlement. So they have instructed now that there is notice that must be given on both sides, from the employer and the employee. The employer must give a minimum of 14 days written notice to terminate the employee during probation. After probation, it would revert to whatever notice period is detailed in your contract, which is a minimum of 30 days up to a maximum of 90 days. And this must be documented in writing. It does not state that there's any reason that needs to be given, just that this notice must be given to the individual. And obviously this is paid notice. It works as the same notice for anything else, that their last working day is at the end of that 14 days. They are to be paid up to the end of that 14 days. Obviously within probation, they would not be eligible for gratuity, but they would be eligible for any accrued annual leave, which we will come on to. If the employee wants to resign, however, we have two conditions for them. They have to give shortened notice, so either 14 days or 30 days, and both of it has to be written to the employer. There are consequences though. If they wish to resign and leave the UAE and not return for work for within 3 months, they must give 14 days written notice. What this means, you've hired somebody from, let's say, India, joins your company and says, actually, I don't want to work here anymore, and says, I'm going to go back to India. What happens at the moment is they say that, they give their notice, they tell you they're going to India, they take their visa cancellation, they don't actually leave the country because they've resigned, it's their responsibility. They don't actually leave the country and they just bounce to another employer. So what's happening with this new legislation is that if this person tries to apply for a new work permit within 3 months, they will be blocked from applying for that work permit, okay? And the original employer will be compensated by the new employer for the cost of the recruitment fees, okay? If the employee wishes to resign and change employer, so they're upfront and they say, look, I've been offered this job, it's got triple the salary you're giving me and 4 days off a week and blah, 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 and I can't turn the offer down. Absolutely fine, totally understand. They have to give you 30 days written notice, and the new employer must compensate the original employer for recruitment costs. The definition of the recruitment costs and the process for how all of this is going to be covered has not yet been disclosed. My expectation with regards to recruitment costs are that it will be limited to, and I use the word limited, but limited to the physical visa processing. So from the application of the work permit through and the offer letter, the work permit, the transfer of the immigration, the approvals there, medical insurance, medical test, and the Emirates ID cost, and the visa stamping. Those sort of governmental costs, plus, if required, a flight in and a flight into the country if hired from overseas. Those are potentially the elements that I would suspect would be transferable. If you've hired somebody using a recruitment agent and there are agency fees, I would be surprised if they are included. Okay, that may affect how people hire individuals. It may push companies to look for recruitment opportunities closer to home, so people who are in the country already, to reduce that expense and to be more careful, for want of a better phrase, with recruitment processes, to make sure that they are 100% confident that the person they're hiring is the correct person for the job. Again, I don't have any details on this, it hasn't been released, but this is my expectation. It may well be that there are different recruitment costs allowable dependent upon the level of the position. Okay, so if it's a directorship per level that you're hiring for, maybe they will consider an agency fee, but I would suspect that there has to be some level of transparency between the new and the old employer with regards to that. Now, this compensation is only going to happen within the probation period and within this resignation of the probation period. After probation period and the employee resigns, there's no eligibility for compensation that's mentioned in the labour law. Okay. Now, if the employee leaves and doesn't comply with this, either doesn't give you the correct amount of notice, is dishonest about their reason for leaving, which would be evidenced by a change of visa, then they will have an automatic employment ban imposed for 1 year. So that's quite a heavy penalty. Now, understandably, we're waiting for details on how this is all going to be processed. We also need to know, and it may be worth you investigating with your PROs at the moment to see how you can identify someone that you want to hire at which point, like before you send them an offer letter, for example, whether that person is, what's their visa status, what's their history, is that information available? One thing to be aware, as I'm sure we all are kind of subconsciously, we all maintain the same Emirates ID number. So within the Ministry of Human Resources and Immigration files, there is a folder or record for each individual person. So there must be a way that is going to be provided to the employers to understand what the history is, and to be aware of, okay, so this person's currently working with this employer, this is how much the costs were, this is what I'm going to have to pay if I hire them within probation period. Okay, it may also mean that there's changes in employment where employers will not hire people who are working in probation, for example, who will only look for people who have completed probation. But yeah, and the probation stays at 6 months, a maximum of 6 months for one contract with one employer. So there's no changes with that.
Sarah,
okay.
I'm going to interrupt you for a second because we're getting lots and lots and lots of questions. And so what I want to do, because I'm on to page 2 of my questions, so I want to get through some of these. So what I'm going to do is, because I know we're talking about gratuity and everything next, so I'm going to take a break before then and go back to some of the things that you have spoken about. So
Sure.
One of the first things is that somebody said, I have a company in Ajman Free Zone. Is there any online source of information that would be relevant for them?
Online source of information for the labour law?
Well, I think they just wanted to know, and I think it comes back to, you have addressed this, but I think maybe as well, just to repeat it, that you were saying that it doesn't matter where you are based unless it's somewhere like DIFC that has additional laws, that this is federal rather than for specific free zones.
And under the definition, and I happen to have a copy to hand because I'm that much of a nerd. Under Article 1 and definitions, the private sector is defined under the labour regulations document as being companies, institutions, facilities, or any other entities fully owned by individuals jointly with federal or local government, companies and institutions, blah, blah, blah. Unless the laws of their establishment stipulate they be subject to the provisions of another law. So that is, and the country it states is the United Arab Emirates. So the geography of the law is all Emirates, and the catchment area, I guess, in terms is the private sector. So that means everybody who's non-government, and it is everybody who's non-government except for those who have other legislation. So for example, people who are in free zones in Ajman, there may well be specific legislation that is for that free zone in Ajman. You would need to go to your free zone authority and discuss with them and get from them what are the new rules as of the 2nd of February. They may say, just follow the labour law. They may say, actually, we're going to adjust what we've got, and this is the new copy, this is the new rules that are coming out. DIFC, for example, are the only ones that were specifically named, DIFC and a couple of others, I think JAFSA and DMCC in places. They were specifically named as saying, we have specific legislation for our free zone, and that's going to stay put. They may amend it to bring it in line with, because generally they're kind of in line with what's in the labour law, actually slightly more beneficial in some areas, but generally it's going to follow the same law.
Okay, great. Next question is there a procedure to end a contract with staff on a limited contract? Maybe if you can just clarify that again.
On an existing limited contract?
Yes.
Yes. Yeah, so you would go through the existing process basically. So you would need, if it's before the end of service, I think what you need to understand is if you're ending that contract, is it because you no longer need that person to do that job, i.e. it's technically a redundancy, or is it just because of the change in terms, but you still need the person to do the job? If it is the first one, then go through the process as normal with regards to giving notice for termination, making the necessary end of service payments. If it is the second option, where actually you just want to change the contract type, because they're already on a fixed term contract, what you can do is give them an addendum to that contract to adjust the new legislation. And then when it comes to renewal, you renew on a new contract, on the new template for the contract.
Okay, great. Someone says, when will we receive the new contract terms format?
Probably next week after the 2nd. The Ministry of Human Resources, unfortunately, there's nothing on their website, and from conversations I've had with them, they're not able to provide any details.
Okay. And if an existing contract requires 6 months notice to terminate, can this be carried forward into the new fixed term contract?
I would suggest you have a conversation with the Ministry of Human Resources on that one, because the legislation is saying a maximum of 3 months notice, 90 days.
Okay.
And technically at the moment, if you have a mainland visa, mainland contract at the moment, a 6-month notice period would not be entertained, to the best of my knowledge. They already cap it at 90 days, but if you have a free zone contract that is not registered with the Ministry of Human Resources, that's where you can have that additional 6 months. So because you're potentially going to have to be lodging your contracts, you would need to have that discussion with the ministry themselves.
Okay. And again, going back to recruitment costs, and I think maybe they didn't hear everything you said. What would fall under recruitment costs to be paid by the new employer to the old employer? Do you want to just repeat that?
Of course. So at the moment, within the legislation documentation, it is not defined what recruitment costs is, what it entails. My expectation would be that it would be all of the work permit application processing, visa application processing, and stamping costs. For example, the offer letter typing and submission costs, the application costs, the labor card application, contract costs, all of those things, Emirates ID, the medical insurance, the medical fitness cost as well. Those elements would be the ones I would suspect would be transferable from one employer to another, because they are quantified, documented, receipted, so to speak, and associated with a company through the Ministry of Human Resources systems. So okay. It is traceable and trackable. That's why I believe it might be those elements.
And we also, you and I have been talking about this before as well, but a few people have asked, how can the first employer be assured that the new employer will compensate them for the recruitment costs?
That's something I don't know. I am sure that the Ministry of Human Resources will have a process in place for that to happen. Unfortunately, at this point in time, they haven't shared with us the methodology of that or the workings as to how that's going to happen. But okay. I don't know that it's necessary. I would hope, again, that it goes through a mechanism within the ministry on application of new visa, for example. Okay, that it's like an invoice is raised or something like this, but I just don't know. I'm guessing.
Okay. And if we are employing somebody post 2nd of February, do we need to go on limited contracts, or have we got 1 year's grace? They said our free zone hasn't provided any new contracts or information.
Okay, so nobody has been, free zones or mainland have not been provided with any documentation or any information on what is going to happen at midnight on the 1st of February in the change to the 2nd. So my best suggestion is that there is, as soon as possible, if you're hiring people, hire them as quickly as possible directly onto the fixed term contracts with the new legislation, providing your free zone offers you that option. The reason being is because it will give you less complications. If you're hiring somebody on an unlimited contract now and you eventually have to transition everyone, the fewer variants you have in the business, the easier it is to manage.
Okay. And is there any provision in the labour contract that allows the employer to add certain conditions, such as extended probation or notice period or compensation, if an employee leaves before their contract expiry?
So notice period will be capped at 90 days. That is according to the law. In terms of compensation, you cannot claim any compensation from the employee for recruitment costs or otherwise. That is clearly stated. I believe it's Article 6 of the Labour Law that states that. And it's got more clarity than what is there at the moment. The 45 days penalty has been removed from what I've seen in the documentation. So you're not going to be able to ask an employee to compensate you for something. And the other query was extended probation. It's capped at 6 months.
Okay, super. Now, last question, and then we'll move on. And that's, is the maximum working hours different in the hospitality industry?
At the moment, there is no clarity on that in the labour law. There is a provision, as I mentioned at the beginning, there are some areas where they're saying this might be changed by decision of ministers within the ministry. That is one of those areas where they've said they may change that, or there may be amendments depending upon the industry. Because I'm aware, obviously, at the moment that you can extend to 54 hours.
Okay. And one other question, and then we're going to move on to the next bit. What about a ban for terminating the contract? Can you just go over that again?
So it's not a ban for terminating the contract. The ban is based around non-compliance of rules within probation period. So if the employee doesn't comply with the 14 days or 3 months outside the country for in probation, or the 30 days to change to another employer, then the 1-year ban can be applied. But it's not generally just because somebody decides to resign on the contract.
Okay, super. Right, okay, let's move on to leave and gratuities and end of service, that sort of stuff.
Yep, fantastic. Okay,
I'm getting to the rest of your questions, everyone. There's still lots of questions. Don't worry, I haven't forgotten about you, but we'll move on to a bit more. Lots of questions around pregnancy and things like that as well. So we'll get to that.
All exciting stuff. Okay, hold on a second. Right, one second. My PowerPoint's decided to.
Would you like me to share mine?
I got it. It's okay. I just need to. It decided to skip a whole load of important slides for some unknown reason.
Okay, no worries. Well, we'll do that.
These things are sent to try us. There we go. Okay. So gratuity. Employees must complete what a lot of the gratuity hasn't changed. Okay, so you still need to complete 1-year employment to be eligible to receive gratuity, even on the fixed term contracts. The calculation is still using basic salary, and it's the daily rate, which is the monthly salary divided by 30 days. And the definition of the month is 30 days according to the law. Okay, it's not 365, multiplied by 12 and then divided by 365. It is the 30 days. And I know it's splitting hairs when you do that calculation. It's like a couple of dirhams difference, but this is the legislation that's in place, and it is calculated from the first day of employment. This is important because obviously we're going to have a lot of people who transition. So you've got people who are on unlimited contracts who will transition, or who are on existing fixed term contracts who will transition onto a new contract. Your gratuity will be calculated from the first day of employment with those transitions. The only, and I'm going to say this, it's not the way around it, but it is an option, is that you can, if you want to finish off the liability and start again, so to speak, is you could terminate an employment with an individual and rehire them. So you need to terminate the contract, cancel the visa, pay out all the gratuity and everything, and then start again from zero with a new contract. That has to be done with the explicit agreement of the employee. It cannot be enforced upon them. It cannot be, do this or else, bullying, whatever else you want to call it. Okay, it needs to be a proper discussion of this is what we want to do and this is why we want to do it. Okay, because obviously, you could have somebody who's at 4.5 years now and you pay them at 21 days, but if you wait 6 months, then they'll be paid at 30 days. So it will have a big impact on the individual, whilst it will also have a big impact on the financial element for the company. So that's understood. So gratuity is paid at either 21 days or 30 days, dependent on length of service, and it's split between 3 years is 21 and 30 days is 5 and over. Now, the next one is there's no reduction in payment on employee resignation. So previously, if an employee resigned within an unlimited contract, they would have their gratuity reduced by a third, so 7 days, 14, 21, and then up to 30, dependent on the length of service. With the new legislation, with the fixed term contracts, this is not in place anymore. You get 21 days or 30 days, that's it. Okay, and that is whether the employee resigns or the employer terminates. There is no cancellation of gratuity if the employee leaves before the end of the contract, for example. That is not detailed in the law at the moment. Again, I give a caveat that this may change because these things do sometimes, and obviously we don't have all the information, but at present, this is my understanding of the information that's been shared. The other thing as well is that the gratuity is protected in case of termination through disciplinary. It appears from the information that we have that Article 120, as we will come on to, has been replaced by Article number 44. And it is not mentioned other than this is termination without notice, whether or not gratuity is cancelled. So it appears that gratuity is still retained if somebody is terminated through disciplinary. Again, this may change. It may be subject to more information coming out next week, but at the moment, this is what it appears to be. You still will come on to the disciplinary elements shortly. Okay. Right, leave subjects.
Sarah, actually, yes. sorry, I'm going to jump in again because we're having, if you want to go back to that other side, I think gratuity is such a massive subject that I think that it's important maybe if we just stop for a second, let's park that and let's have a nice conversation about gratuity because I have a gazillion questions. So I want to go through that because this is, I think this is an area where a lot of company owners get confused. So yes. The first one, for the end of service, does commission need to be calculated as part of that calculation?
That depends on what is written in your contract of employment. Normally, commission is payable based on achievement of certain targets. If the person, and depending on whether you pay it in arrears or not, that depends company to company, if the person has achieved their targets and you have agreed to pay them XYZ amount of dirhams because they've achieved their targets, then you need to pay that person. If, for example, the person finishes on the 31st of January and you haven't yet worked out the commission for January, you either make an agreement to prorata it or make an educated guess, so to speak, on what that commission might be based on previous history, or agree in writing to pay them the balance of that commission once it's been calculated after the 31st. But legally, according to the definition for end of service, it's any annual leave that's balance, accrued balance, it's salary up to and including the last working day, and it's gratuity if applicable.
Thank you. Okay, next one. Basic salary versus total salary. Can you explain that in a bit more detail and what the rule of thumb is for that and what's allowed?
Okay, so companies have different structures with regards to salary. Some companies will, and this is possibly going to be a bit of something maybe new information, but within when you set up a contract for an individual, you can break the salary down into portions, being basic salary and then allowances, and you can define those allowances. The common allowances are housing, transportation, could be mobile phone, could be a schooling allowance, could be flight ticket allowance, for example, okay? Meal allowance is another common one. The general rule is the total, obviously, including the basic, adds up to 100%, but the general rule is that the basic salary and best practice should be split 40% basic, 60% allowances, and then you can break the allowances down between the 60% of the salary, or vice versa, that 60% is the basic and then 40% on the allowances, 50-50, whichever way you want to split it this way. You cannot put forward a zero salary contract. You need to pay a minimum of 100 dirhams as a salary. You don't necessarily need to give allowances, but you need to pay a minimum of 100 dirhams as a salary to an employee in order for the Ministry of Human Resources to accept your contract. When we're talking about gross salary, this is basic plus allowances, okay? And that's everything total. And that is when you're talking general salary, when you're talking salary paid up till your last working day, that is your gross salary. And also when you come to calculating annual leave, that is your gross salary. Basic salary is just that basic element, and that is what is used for calculating your gratuity. So it could be 10,000, 12,000, whatever it might be, or 5,000, 1,000 even. That is what's used to calculate your gratuity. Does that answer the question?
Yeah, I think so. And another one was as well, is it mandatory to provide a plane ticket home each year, every couple of years, or is that not a requirement?
No, it's not a legal requirement to provide tickets except in repatriation situations. So if somebody is terminated from the employment or they come to the end of the contract and it's not renewed, then it is the responsibility of the company to repatriate the individual back to their country of origin, not their country of hire, because quite often these days we hire somebody from the UAE, but they actually come from another country. So it's back to their country of origin. There is that responsibility. Other than that, it's not a legal requirement to provide a ticket for annual leave. It is a benefit that was put in place many years ago, somewhere back in the 80s, I believe, which is gradually being phased out. Many companies that I'm aware of are actually providing allowances that they would either give a fixed amount of money on the anniversary of employment or on the calendar anniversary, or a small token contribution with the salary on a monthly basis, for example, to allow and say, that this says your salary, it basically covers whatever you need to do for tickets and things, and then it's the individual's choice as to how much money they spend.
Okay, excellent. And then one person just added about the minimum 100 dirham basic salary. Is that going to be impacted once the rules around minimum wage are announced? And do you have any idea when this might be?
No clue at all when the minimum wage announcement will come, or what it's going to affect, or what it's going to look like. I've not had any information about that. And yes, probably it will have a difference. What I would suspect is that because obviously within the job title structure that we have in the Ministry of Human Resources for employment contracts, we have unskilled, skilled, supervisory, management, for example. I would suspect that there may be a minimum wage associated with those skill levels and the different job titles. So it may be affected in that regards, but I have no information on that at the moment, I'm afraid.
Okay. And someone said, just to confirm, the end of service is calculated from the initial start date of employment and not the date of the transition.
If the person is in continuous employment with you, where you've done an amendment to contract, or you've transferred amendment on an existing fixed term, or you've transferred them with agreement from an unlimited onto the new fixed term, then it is from their first day of employment, be that 2020, 17, whatever it may be. So it's continuous.
Okay, and from an employer point of view, the gratuity payment for the first 1 year and second year is 21 days. She said, I heard it's only 18 days for the first 2 years. Can you clarify?
To the best of my knowledge and the information I have, it's 21 days.
Okay, and when does the gratuity need to be paid? Is it a certain number of days after the employee's last working day?
Yes, legally you have 14 days to settle all end of service benefits after the last working day of the employee.
Okay. Now, this is, I'm sure you have views on this, I certainly do. What if the employer does not have the money to pay the end of service benefits? Does the employee take the owner to court? What are the options?
Okay, so if the employee, so legally the employer has will have to pay the employee within 14 days of the last working day. And if they don't pay, for whatever reason, the employee has the right to make a complaint with the Ministry of Human Resources. And whether or not that goes to court is then up to the negotiation between the employer, the ministry, and the employee. Okay. It is a bone of contention because obviously, especially with the COVID challenges that many companies have faced over the last couple of years, cash flow has not been there. However, it is something that I personally believe that there needs to be part of your monthly costing ought to be accruals for annual leave and gratuity, so that you don't get into the situation of not being able to pay somebody gratuity.
Yeah, I 100% agree with you, and we're doing more finance sessions about that as well, because that's really important if you're running a business, that you need to take into account, even though that money's not leaving your bank account at the moment, that at some point in time you are going to have to pay that employee's gratuity. So whether you're putting it into a separate bank account or keeping it there, that it needs to be available at any given time. Is there, okay, so just going back, we're getting lots of questions about the length of service. Someone's saying, I heard it's 21 days for 3 years, 30 days for 5 years plus. What about 4 years length of service? Any clarifications on all of this yet?
If you give me, so I'm just consulting my end of service benefits. So the statement is that providing you've completed a year or more in continuous service, the foreign worker is entitled to end of service benefits upon the end of his service, calculated according to the basic remuneration as follows: 21 working days for each year of the first 5 years of service and 30 working days for each year after that. So if somebody's worked 1 year, 2 years, 3 years, 4 years, 5 years, it's 21 days, 5 years and 1 day, it goes up to 30. Over that goes up to 30. Okay.
Perfect. Okay.
And that's verbatim from the law.
Yeah. And then is there a penalty for the employee if they decide to resign before the end of the contract? And they said, I'm aware that this is at the discretion of the employer, not anymore. Right.
It's never been at the discretion of the employer, except in fixed term contracts. In unlimited contracts, the legislation is there currently that gratuity at end of service is reduced according to length of service. In fixed term contracts, if the person leaves before the end of 5 years, if I remember correctly, it's forfeited unless the employer decides to pay. That's their choice. But with the new legislation, there does not appear, from the information I have, it does not appear that there is any reduction in gratuity for leaving prior to the end of the contract. Okay.
Last question on this. Someone says, what are the legal steps against an employer in a free zone that didn't record the contracts that the Ministry of Labour asked people to work on a visit or their own visa, and after that didn't pay the salary to its employees?
Okay, this is a tricky one because legally both the employee and the employer are at fault here. It is illegal to work, as I'm sure everybody knows, it's illegal to work in the UAE without a work permit, and it can be a work permit issued either by the Ministry of Human Resources or from one of the free zone entities, and to have a visa associated with that for your residency in the country. Having a visit visa or having even a dependent visa or even a golden visa does not give you the authority and right to work automatically. So technically the employee has no legal rights because they don't have a contract, they don't have a visa, they don't have any formal obligations with the employer. And that makes it difficult. My best suggestion, if there is someone in that situation, is to go and talk to the free zone authority concerned, or go and talk to the Ministry of Human Resources. But I would suspect the response will be, sorry, we can't do anything. However, by at least talking to the authorities, a complaint may well be registered, even if it's not actioned, which would then support future complaints coming through and build a case, as it were, against a company that may be a repeat offender in this instance.
Okay. And very last question. Someone wants to know if their employee doesn't want to renew their, or sorry, if an employee wants to renew their contract upon expiry but doesn't want to go back to their home country, are they eligible for cash reimbursement of their air ticket?
I'm sorry, I don't. So again, if they want to renew their contract but don't want to go home in between.
Yeah.
Yeah, that's up to the employer. There's no legal guidance on that one. If you want to give them a cash alternative, that's entirely up to you. Considering that this is not a repatriation ticket, because it is continuous service from one contract to the next, just renewing in between. So this might be an annual leave. They may be going home for their 1 month annual leave. And they're saying, actually, I'm going to take local leave. I'm going to stay in Dubai and see the sites. It's a totally company prerogative if they want to pay and encash that ticket and the value of it as well.
Okay, perfect. Now I'm going to let you move on. We have lots of questions about terminations, so we're going to get to that next. Excellent.
Okay, no problem. Okay, so gratuity covered, right. Leave. So annual leave. Somewhere it is pretty much the same as what we have at the moment. It is 2 days per month for anyone who's joined a company up to their first year, completion of their first year of employment, and then it switches to 30 days after that, and these are calendar days, as we've said. This is all with full pay, and this is specified in the Labour Law, whereas previously it's been basic pay plus housing allowance, for example, okay? The one change that we have is that the 2 days per month during probation can be applied for and can be approved with pay by the employer, okay? And the other element as well is that if somebody leaves during their probation, let's say on the last day of their 6 month probation, they resign, they've given you the 14 days notice, you still have to pay them their 12 days or whatever balance that they have for that accrual. And the same would be for any point during the probation, okay? So technically whereas previously we probably only accrued after that, we probably sort of got to the end of their probation, and right now they've got 12 days. We now need to say at the end of the first month, they've got 2 days, 4 days for the second month, blah, blah, blah. So that if somebody resigns during that time, we need to give them that financial compensation for the annual leave. Sick leave has stayed the same. It is 15 days full pay, 30 days half pay, 45 days unpaid. The one minor element that's changed is that you've got 3 days you must inform your employer within 3 days, which I think is a little bit of a stretch, but and it has to be medically certified in order to achieve this. Obviously, if you turn around and say, look, if you want 1 day off and a sick leave and we don't need a medical certificate, you can self-certificate for 1 or 2 days, that can be a company policy. That's not a problem, because that's more than the law, if that makes sense, okay? Maternity leave, we've got quite a few changes around maternity leave, and I haven't gone into depth on this because there is a lot of information and a lot of elements with regards to it. There is now no minimum service length, or will be no minimum service length. Previously, with maternity leave, you had to have been employed for a minimum length of time before you would be eligible for the 45 days full pay. This is not the case any longer, I'm afraid to say, or I'm pleased to say, because I can sit on both sides of the fence as someone who may be pregnant, but also as an employer as well. So it means that from day one of employment, the person is then eligible for the 45 days full pay, and then the additional 15 days at half pay. This can also be extended to 45 days without pay, subject to meeting certain medical criteria. And this is in the case of either the mother or the child being medically unfit, ill, facing complications either through pregnancy or birth, okay, or due to pregnancy and birth. So that could be, for example, having a cesarean or something like this, okay? Other elements to note are there is an acknowledgement that if a mother has a stillbirth and they have been pregnant for at least 6 months, they are still eligible for the maternity leave. That's one of the other big ones that's there. And again, that's something I've not mentioned here because it is quite a major change. It is a sort of quite a detailed situation, okay? There are provisions for a female worker if they give birth to a sick or disabled child. which can be extendable and giving an extra 30 days without pay. But again, this has to be documented by a medical certificate. Okay, there is protection for the pregnant female worker in that if they declare that they are pregnant or it's suspected that they are pregnant, they are protected from being terminated from their employment because of it, which I think is good, because I've heard horror stories of where people have been terminated because they've said, I'm pregnant, I need maternity leave in 6 months' time or 9 months' time, and it's too complicated or expensive for an employer to handle. And this is, it supports the big companies who are able to maybe accommodate maternity leave from a financial perspective more readily than smaller businesses, and I totally understand that. However, this is obviously something that the legislation has picked up when they've done their research about changes to be made. This is one of those things that they've picked up to say, actually, you know, there are a lot of people who are saying I've been made redundant, you know, been terminated because I'm pregnant, kind of thing, and that comes back on the discrimination element as well. Okay, the other additional thing is the rest break. So previously we've had a period of it's now 6 months where it was 12 before, that from the date of delivery that you're entitled to either 1 or 2 rest breaks per day for breastfeeding, and that period does not exceed 1 hour. So it's been reduced from the 12 months down to only 6 months, but that's probably because you've got the additional 15-day additional days in terms of the actual maternity leave itself. Okay, so parental leave, this can be for either the mother or the father, and it is a total of 5 days with full pay that can be taken during the first 6 months of after birth of the child, and these can be consecutive or ad hoc, so you can take 1 day a week for 5 weeks, or you can take all 5 days in 1 week. It's fine. There is no stipulation of saying if you employ both parents that it's only once. So it's worth noting, if you have got parents you've got couples employed within your company who are going to be having children, you may be required to give out 10 days for those 2 people because it's 5 for each, for example. Okay, and the last one that we have is a number of various holidays that have come up, and I picked up the compassionate leave because that is a brand new one that's come, and they are providing compassionate leave with full pay for 5 days if it is in the event of the death of a husband, wife, and then 3 days if it's a mother, father, son, brother, sister, grandson, grandfather, grandmother, and it will be starting from the date of death, and obviously the death certificate would have to be shared for that to be eligible. One other or a couple of other elements that are there is with regards to the study leave. Everybody got really excited about the study leave, but the study leave is not just for general study. It's actually for study for the betterment of an individual or for the continuation of licensing for an individual whilst they're employed. And then for the job, and providing it has to be within the country, so they can't do it outside of the UAE, for example, and they have to be employed by the employer for 2 years as a minimum in order for that to be eligible. It's a total of 10 working days per year. Okay. The other one as well that's mentioned is with regards to national workers, and it's interesting to note at this point, and it's very refreshing to note at this point that there are a number of references to national workers over foreign workers, not with preference, but that they are mentioned within the labour law, that they weren't previously so much. The national worker is entitled to full-time leave to perform the National Reserve Service with pay in accordance with the legislation in force in the country. So if, and this is the case now, but it's not well documented and known, if you employ an Emirati in your company and he's called up for national service, he has to go and you have to pay him for that national service period. Okay, and that's going to be reflected in the new legislation as well. Any questions around annual leave and any leave elements, Jen, or do you want to move on?
Oh yeah, no, we've got a lot. Okay, so first of all, we're going to talk about pregnant employees and managing all of that. So they want to know, can they terminate the employee after the date of delivery? For example, during her maternity leave, what's the notice period required? And also they want to know what, to give more clarity about the breastfeeding break, if it's 1 hour daily or 2 hours, so 2 times 1 hour breaks, and how long are they expected to work for? So all of that.
All right, so I'll answer the easy question first, which is about the breastfeeding breaks, okay? So it's 1 hour break per day, and if that wants to be split into 2 half-an-hour breaks, then that can be done, and that is at the request of the mother or the female worker, not at the employer, okay? So if the female worker says, I want to come in half an hour later in the morning because I'm breastfeeding, or I want to take an hour at lunchtime because I'm breastfeeding, or I want to leave half an hour early in the evening because I'm breastfeeding, then they can do that. But it's a maximum of 1 hour per day, okay? It's for 6 months only, right? And I think that answers that question.
Yeah.
Okay, so with regards to terminating people who are on maternity leave, there's nothing defined in the Labour Law saying you can't do it. However, as an HR professional, I would recommend that you don't. It is mentioned that it's not permissible to terminate because of pregnancy, or because she's taken maternity leave, or because her absence from work in accordance to this. So I think the best advice is to wait until they return to work. And then if you need to performance manage them out of the business because they're not performing before they went on maternity leave, then that's what you need to do and follow the disciplinary process. If it is a redundancy case where that role is no longer needed, then when they return to work, you have that conversation and documentation discussion with them to say that this position is being made redundant. Okay. The reason for termination cannot be because you took maternity leave, because you extended it, because you are pregnant. It cannot be that. It has to be something else. Okay. And I would err on the side of caution and do it after they've returned to work. If somebody is incapacitated, and this is where maternity leave can tack on to sick leave and get a little complicated. So whilst there are these provisions for extendable maternity leave rather, with medical, meeting various medical criteria and being medically certified, if someone then sort of wanted to return to work and then said, actually, I need to take sick leave, and goes on sick leave with the 15 days or 30 days, and then the next 45 days is unpaid, you could terminate someone at the end of sick leave, providing they are unable to return to work, in that they are physically unable to actually do the job, if that makes sense. Okay, that would be the only way, but that is not a provision under maternity leave.
Okay. Next question, they want to know, maternity leave, is it natural days or working days?
It is not specified as being working days, therefore it can be assumed that it is calendar days.
Okay. Now let's move away from maternity for now. Talking about holiday. So people are just asking for clarification about, is holiday annual leave 21 working days? is it 21 working days or 30 calendar days? How are they calculating it? Or 30 paid working days? We're getting lots of questions around what the actual amount is for holiday.
So the specification in the Labour Law is 30 days for each year of extended service, 2 days for each month, and if his service is more than 6 and less than a year. Okay, so it's paid full salary and it is calendar days. Unless the thing with the law is that unless it says working days, it means calendar. The way it's written, okay, because they are specific in certain instances of saying this is X number of working days, this is X number of days, for example. So maternity leave and annual leave just mentions days. If it is there's just somewhere. So parental leave for 5 working days, for example. So that does not include your days off. So that's where that differentiation is made within the detail of the law.
Okay. Sick leave. When can an employee start taking sick leave after they've gathered 3 or 6 months of employment?
It's once they've completed their probation and then a 3-month period after that.
Okay, so if their probation was 3 months, they could start having sick leave after another 3 months.
Another 3 months, yeah.
Right, okay. And someone wants to know, sick leave can only be counted if there's a medical certificate. What if an employee won't provide a medical certificate?
Legally, it states that it needs a medical certificate. If, however, you want to allow individuals, some companies allow individuals, if it's only 1 day, for example, that they self-certificate themselves, where they basically say, I'm sick, I'm not coming to work. Some companies allow that. That's going over and above what is offered within the law, if that makes sense. So it's not illegal. It can be a company policy to do that. But I would still maintain that it's part of the sick leave, that it's still that sort of 15 days. You document it the same way in regards to any internal systems and processes. Because if you have somebody who's repeatedly doing this, you would then look at it as being an issue.
Okay. And are there rules for employees who are on temporary limited paid per hour contracts to have annual leave, sick leave, gratuity? And how is that calculated?
So these are, as I mentioned with annual leave there, annual leave, gratuity calculations and sick leave elements. It's not identified yet, it's not been detailed yet how this will be played out, even maternity leave and other stuff. It's not been detailed how this is going to play out for the various flexible working options. So the condensed hours, the part-time workers and the hourly workers, that has not been shared with us. That I would suspect will come in the executive regulations document or the further ministerial decrees that will come in time.
Okay. And if somebody is on leave due to COVID, is that counted as sick leave?
Yes.
Okay. And people are also asking as well about how much can be carried over, roll over to the next year for annual leave.
Whatever anybody has earned, they must carry over. It is illegal to cancel it.
So what if somebody doesn't take their holidays? So if you have somebody who hasn't taken holidays the whole year, can the company force them to take holidays or pay them for those days?
Yes. So you've got the 2 or 3 options is that you carry over the 30 days to the next year, which is far from ideal. You encash the annual leave as if the person was taking it, which means you need to pay them full salary at the end of the year, and then start them with a 0 balance on the calendar year of January the 1st. Or you force them to take their annual leave. And to my mind, that is what should be happening. That's the most common sense. If you think when you employ somebody, you employ them, let's say from January to December, that's 12 months salary, and that's what you budget for. That 12-month salary should include 1 month annual leave. If you don't encourage, push, direct, coach, whatever else word you want to use, except bullying, please, people to take their annual leave during the year, you are essentially going to end up paying 13 months salary for that person. Okay, because you will have them working from January to December, and then they've got 30 days, which is another month's salary that you need to pay. So my recommendation is to allow people to take leave in advance of them earning it. Have a clear discussion with them that, look, if you take 15 days and you leave after only earning 7, you owe me 7 days. Okay, and that can be deducted from the gratuity, and that is and any end of service benefits, and that's supported by the law. But what that means is that you can manage your leave through the year to make sure that people take it when it is convenient for your business, and also that you only pay that employee 12 months salary.
Okay. And what if someone said, what if I can't allow my employee to take their annual leave? The business requires them to be at work.
There's no problem with that. They have removed the, so they used to, in the old law, which is something not a lot of people knew, there used to be penalties that if the employer says, no, you can't go on leave, you used to have to pay them the balance of the, the amount of leave plus like 150% or 200% compensation kind of thing, something along those lines. They've actually removed that, but what they've said is that you can encash it. So if, for example, you're not able to allow a person to go, then you encash it, but you encash it at full salary in that regard.
And is that, somebody's also asked as well, is it paid on the basic salary or total salary?
So if you are encashing the leave, okay, you've got two situations. One is where the employee has refused to take it, and I would pay that on basic. And the other where the employer has said, no, you can't take it, and I would pay that on full salary. In the event that somebody is resigning from their position or being terminated, it's payable on basic salary.
Okay.
Where somebody goes on vacation, when they actually go on holiday and don't come to work for 2 weeks, that's paid on full salary.
Right. And if the employee refuses the cash and insists on their leave?
Then that's their right.
That's their right to say that they don't want to be paid out, they actually want to have holiday.
Yeah.
Okay, super. So that question is answered. Right, we have another section to get through on termination. So everybody else, park your questions. Maybe we can convince Sarah to stick around for a few minutes to get through all of your questions. I have them all written down, I promise.
Of course, no problem. I'm all yours. I can be yours until 2:45 if necessary.
No, we're not staying that long, Sarah. But we'll get through some more.
Excellent. Okay, let's carry on. Okay, so this is disciplinary. The disciplinary has always been in the labour law. They've adjusted it slightly because they now have a written notice, which before was the verbal warning. And I think a lot of companies failed to document the verbal warnings. So they've actually sort of said, look, this needs to be a written notice now. And then you've got the various deductions that can happen, the suspensions, deprivation of periodic bonuses, denial of promotion, and dismissal from service while preserving the worker's right to an end of service benefit. For any and all of this, it's my personal recommendation, and documented within the law to a certain degree. Obviously, where you have a written notice and a written warning, it's obvious that it needs to be written, but I would recommend that you have an investigation and a discussion and a proper process for disciplinary to support the individuals, but also to support the company in case of query and complaint. If an employee is terminated, even with end of service benefits, for a disciplinary matter, they can make a complaint against you for arbitrary dismissal with the Ministry of Human Resources. And if they do that, you would have to pay and settle up to 3 months worth of their salary plus benefits plus. Okay, and that's something that you don't necessarily A, want to pay for, and B, need to go through the hassle of, because having a labour case against you is complicated. So having everything documented, having it written down, not only for the records, but also here's the minutes of the discussion that we had, here's the evidence that we have, this is what you say you did, this is what witnesses say you did, this is what, this is the disciplinary hearing and your explanation of why you did what you did. This is what we're going to do to make sure it doesn't happen again. And this is your punishment, for want of a better word. You're going to get a deduction, you're going to get a written warning, we're suspending you from work, or whatever it might be. Documenting that and actually getting the employee to sign to acknowledge that they understand it. And write it in Arabic, write it in English, make sure the person understands it. For people who are illiterate, make sure it's read to them, and that they confirm that it's been read to them, that they understand, and put their thumbprint, their signature, whatever it may be, with a date. And you they get a copy, and you keep a copy of that signed acceptance. That then is your defense, for want of a better word, in case there's any complaints and queries. But it also gives you the support that if someone does it again, you can then escalate the process in terms of disciplinary. Okay, one of the regulations with regards to the new Article 120, which is now Article 44, is that you need to have 2 written discussions, written investigations and disciplinaries, warning someone that if they do this again, they can be terminated. So this is why you need to have that documented evidence of this happening. Okay, so as I mentioned, Article 120 will now be Article 44. The main points remain the same, and I can read those out to you with regards to, hold on a second, I think they've shuffled the order momentarily on them. So it is misrepresenting yourself, having false certificates, committing a mistake that results in serious material loss to the employer, or the worker deliberately harmed the employer's property and acknowledges it. You have to inform the ministry within 7 working days. Previously, it was 48 hours. If the worker violates the instructions of the facility's internal rules and law with regards to safety and workers in the workplace, providing they're written and conspicuous, and the worker has been informed. Point 4 is the worker's failure to perform his basic duties, which is where this disciplinary comes in, because his basic duties in accordance with work contract and the continuing breach despite conducting a written investigation with him for this reason and warning him twice of dismissal. Okay, so this is where you can only dismiss somebody under this Article 44.4 if you've had the disciplinary twice in writing. Okay, and that's why it's important. And that's dismissal without notice. Otherwise, you terminate with notice and follow the rules on giving gratuity and end of service and stuff. If you disclose a work secret related to industrial or intellectual property, which results in losses, or brings a personal benefit to the worker during work hours is under drugs or influence of drugs or alcohol, or committing an act against public morals in the workplace. If the worker assaults an employer, manager in charge, one of his superiors or co-workers, verbally, actually, or any form of assault punishable by virtue of the law. So that could also be slanderous comments or defamation comments on Instagram, Facebook, or somebody's LinkedIn page or something like this as well, okay? Because they would be covered under the cybercrime legislation. Absence is the same, so more than 20 intermittent days and 7 consecutive days you could be terminated with no notice. And the last 2, which are the 2 that I put here as additional points. The worker illegally exploiting his job position to obtain results and personal gain. So that's people taking bribes, backhanders, under the table payments, whatever you want to call it. And the other one is the employee starting to work for another employer without following the rules and procedures for their current employer. So that is reflecting the fact that somebody might be a part-time worker with you and also then take a part-time position with another company. There's obviously going to be rules that come that say that communication has to happen, and there needs to be some disclosure with regards to that. Okay, Jen, do you have questions around that?
Right. Let's get to the rest of it. And then I know, guys, I probably have about, or I should say ladies, I probably have about 15 more questions to get to, but they're more sort of general that we'll do at the end.
Cool. Okay.
So
we've done the exciting bits. We're pretty much at the end anyway. So one of the things, and you know, I've worked in a number of different companies in the UK and the UAE, Qatar, Kuwait, what have you. And over the last year or so, as I've been working with my business, getting involved in a number of different companies and different industries and things. And one of the things that I've noticed is with regards to communication. And this is why I put 2 hint tips, best practices here with regards to communication. Clear information is key. The more information you can give to an individual with regards to how things happen in your company, the better, because it's clear and transparent, which builds respect, it builds trust between you and the employee, but also it means that if you get them to sign acceptance of that or sign receipt of that document, so to speak, you have more strength to your elbow to say, how did you not know that this was the rule? Okay, so for example, under the Ministry of Human Resources, we provide an offer letter from them, and it's a very formulaic offer letter. And then we have a contract from them, which mirrors pretty much the detail that's in the offer letter. But the information that's in the offer letter is very, very brief with regards to details. There is a comment at the bottom that says, you know, this is supported by appendices. I haven't yet come across a company that provides those appendices, which is essentially the labour law, to the employee. And if I was a new employee coming to the UAE and I was presented with this bulk document of all of these appendices of the labour law, which is not written in maybe the most comfortable English for the majority of non-English speakers or second language English speakers, I would be quite put off by that and find it quite complicated. So what I would recommend is to have something called a letter of intent. It's not necessarily a legal document, but it's your intent of, I'm going to hire you based on these criteria. This is the salary, this is how it's going to be broken down, this is your annual leave requirements, this is your sick leave, these are the rules around termination, these are the rules around resignation, this is about your flight tickets, this is about your medical insurance. And it can be 3 or 4 pages long, but it gives information to the candidate before they come about what's going to happen, okay? As long as that matches the requirements of the labour law and then what is provided as the clauses in the offer letter, then it will be a valid document. The only time it doesn't is if what is in the ministry offer letter is better than what's in your letter of intent. If there's any conflict between any of it, whatever is the better benefit for the employee will prevail. Okay, so it's worth making sure that you have that pretty much lined up. But having that letter of intent and having that detail for the employee and prospective employee starts building that respect and that trust element before you come, and actually helps with the whole process. That then falls into, once you've arrived in a company, providing people with, and again, it doesn't need to be printed, it doesn't need to be particularly pretty, it can be an A5 document, it can be a PDF that you send out, it can be a video, it can be whatever you want, okay? But you provide them with a code of conduct or an employee handbook, giving them, okay, this is the company information, this is how we expect you to work, this is the rules and regulations, this is how we expect you to behave. If you need to go on sick leave, this is what we need you to do, whatever. Have a page on that, you can have it in that or separate to say, I hereby understand that I've read and understood and agree to all of these code of conduct or this employee handbook details, policies, procedures, okay? As was mentioned when we were talking about the disciplinary issues in Article 44, it will help you in the case of dismiss, in the instance that you need to do disciplinary, but also to dismiss somebody without notice, because that is a document that says you must do 1, 2, 3, 4. They've signed it to say, yes, I'm agreeing to do 1, 2, 3, 4. If they don't do it, you've got that to fall back on, okay? And as I've mentioned with regards to documenting all disciplinary performance conversations, make sure the employee gets a copy and make sure you get a signed receipt or someone to sign witness that it's been given to the individual, because they then can't say that they didn't receive it. One other additional little pearl of wisdom on this one. If somebody resigns, and this may be something that many of you do already, if someone resigns from the company, acknowledge in writing that resignation from the company officially. It can be an email that is legally accepted as a written document these days, but document it. So I hereby accept your resignation dated whatever. This means your last working day will be blah, blah, blah. This is what we need you to do, return company property, whatever it might be, okay? Because by providing that communication to them, it's acknowledging and supporting that you're accepting their resignation. I've had fingers burned with that one from personal experience, where that didn't happen and it was a very costly experience. Excuse me. And then coming on to annual leave accruals and accounting, which we've kind of touched on. I would anticipate that, and you can do the same for gratuity as well, but I would expect with robust recruitment procedures that every employee should stay with you at least 1 year. Therefore, you will need to start accruing for 2.5 days. It's better to do it to financially accrue it. And what I mean by this is saying at the end of every month, I have 6 employees. I need to take 2.5 times 6 days pay for each 1 day's pay for each employee and put it into a savings account. Okay, so that by the end of the year, you have 1 month's salary per person sitting in that savings account. So that when someone takes their annual leave, you don't deduct, and this is more for small businesses and things than I would suppose that most major companies would do this, but you don't deduct that annual leave salary. So when someone goes on holiday, you have to give them salary in advance of going on holiday. Well, you don't take that from your cash flow, you take it from your savings account. Okay, and I know that sounds like a little bit cack-handed and stuff, but if that comes from your savings account, it supports your cash flow. You have your salaries and cost of salaries, which goes into your accruals every month, and then it sort of just helps that process through. If you do the same for annual leave ticket, if you provide it, and definitely for accruals, it will mean that when someone resigns, you don't have to have a flat panic of where am I going to get the money from. It's in your savings account. Okay, and when somebody resigns, or if somebody gets terminated, or and you end up not paying them the annual leave or whatever it might be, you can then do a reverse accrual and recruit and reverse that money and shift that money back into your cash flow, or keep it in your savings account for a future employee, for example. Okay, so those are my sort of key hints and tips. The first two are the ones that are most important for me as an HR professional, especially when I'm dealing with employees and what have you. And that's we're done, I think.
Okay, we have a number. Yes, so we have a number of questions which I'm going to go through. But what I would like to do, and I would be grateful, it's amazing that you stuck on, because everybody has so many questions, and we have so many of you who have stayed as well, which is phenomenal. This is pure gold. Could I please ask everybody, we're going to bring up a poll super fast, and I would be very grateful if you would answer these two questions on the poll. It's really important for UN Women and NAMA Women Advancement that we actually just get these figures as part of the reporting, so we can share with them how the workshops are helping you within your business. So if you could please help us out by doing that. And then what I want to do is I'm going to go back and answer all of these questions with you, Sarah, because we have a lot. One of the first ones, let's go into this, because we get a lot of questions on this. And I know, especially if you're a new business and cash flow is tight, but you need extra people and you're looking for other ways that you can bring employees into your business. One would like to know about the work permit for the 15 to 18-year-olds. Can you talk a bit about that, and maybe how small businesses, like especially ones, maybe if they're in a mall and they have a kiosk or a shop, maybe they'd like to hire teenagers part-time. How does that work for a small business? How could they hire a teenager? Okay, so
it is quite strict with regards to what you can and can't do with employing, as the law calls them, juveniles. But I prefer the word teenager or young adult. 15 is the minimum age, and then it's anyone up to the age of 18, which is the normal sort of catchment area. The requirements are they cannot be employed between 7 in the evening to 7 in the morning, so there's no overnight work. They cannot be employed for dangerous or arduous work, or works that by their nature will cause harm to his health, safety, or morals. So I would suspect that would be, you can't have them working in a bar, for example. I would suspect that might be the morals element. And health and safety is going to be construction work and things like this. Not that it's not safe, but there may be a question over eligibility for that. And then they cannot work overtime, all right? So if you employ them for 3 hours a day, they can't work anything over 3 hours, that's it. Which is quite limiting, especially in a kiosk where maybe you've got to be confident that someone who's going to come and take over the shift is going to actually arrive on time, because you don't want, I'm not talking 5 or 10 minutes, I mean hours. They can't work a double shift, for example, okay, because it is quite limited on that. And the actual working hours is a maximum of 6 hours, and including 1 hour of rest, okay. It can be broken into multiple parts, but it's not more than 1 hour of rest, and they can't work more than 4 hours consecutive straight. Now, this obviously is what's written in the law. I think, you know, there's not many kids that are going to say, okay, I can't work more than 4 hours and that's my time is up and finished. They're more than likely to work a little bit longer. You know, this is where, as long as you have the clarity on things, it's not going to come into, and it's not repeated regularly, then it's not going to be an issue, and the individual or the guardians are not going to complain. You need to have written consent from the person who has guardianship or trustee, so the parents or the legal guardian of the individual, and you need to have a health certificate, a fitness for work, which needs to be issued by the medical authority, by the doctors, okay? It is mentioned that prohibited to employ, sorry, I'm just reading because it's not written. I'm reading what's written at the end here. So, yeah, it's there's still information to come on the process for this, how it's actually going to happen. I believe it's going to be similar to the work permit applications that we have at the moment, so that you would go through the Ministry of Human Resources and say, I want to employ this person for this job, this number of days. Here's his passport, here's his visa, here's his health certificate, here's the passport from his legal guardian, and basically the NOC from the legal guardian. Then you can go ahead with it. That's as much information as I have at the moment.
Okay, always evolving. So,
yeah.
Excellent. Okay. Other question that people have asked is can an employee legally have 2 jobs in the UAE, and how does that work?
Yes, at the moment, so there will be, this is one of those areas where there's more information to come, because when you say 2 jobs, it could be 2 part-time jobs, it could be a full-time and a part-time. It's unlikely to be allowable to have 2 full-time jobs, to be honest, or anything that's over 48 hours. So you couldn't have 2 jobs, although they're talking about doing condensed working so that you cover 48 hours work in 2 days or 3 days, meaning that you could essentially do another full-time job as condensed hours in the rest of the week. It's unlikely that they would approve that because it would all need to be registered. At this point in time, that's as much detail as we have. As these are new areas of employment from the ministry, there'll be executive regulations that are coming out, which will give more details onto the process, the mechanisms, documentation that's needed, and how that's going to work. At the moment, somebody can work for more than one employer. You can have a full-time job and then apply, but you have to apply for a part-time permit through the Ministry of Human Resources.
Okay, and what about if somebody has a full-time job, but they also want to have a business? How is that going to work? So if they set up their own company?
To the best of my knowledge, that's not governed by, nobody governs that and sits and says, no, you can't do that. Obviously, if you're setting up your own company, if you have a mainland visa, you can get an e-trader license. So that would, there's nothing that says, no, you're fully employed, so you can't have that. I know people that have gone through this, so that's not regulated at all.
Yeah, and that depends on what emirate you're in as well, and where your visa is from as well. But there's different options in different emirates that will cover people as well for that.
Yeah.
Okay, my big long list of questions. This is quite straightforward. I'm going to give you this to answer whilst I'm pulling up some of the other ones in groups for you here, which is if you're on a dependent visa, can you have a work permit as well? Can an employee work with a work permit and stay on a dependent visa?
Yes, absolutely. Anyone who is on a dependent visa with a visa states not eligible to work, providing the company you want to work for applies through the Ministry of Human Resources in whichever emirate, so Sharjah, Fujairah, whichever, for a work permit with an NOC, copies of visa, passport, Emirates ID of the sponsor and the applicant. Then they can apply for a work permit, and you will get a contract the same as everyone else and a labour card the same as everyone else. That person will need to be paid through WPS if you are a non-WPS company, but yes, you can do that.
Okay, super. And
sorry, just to say it must be done that, because otherwise you're illegally working.
Yeah, you can't just have somebody turn up. You still need to do all of the requirements, because there's still the requirements for holiday leave, sick leave, end of service. Yeah, you still have to pay that. The only thing that sometimes some companies don't have to pay is health insurance, because that's covered by their visa if they're on a husband visa or something like that.
Yeah, that's correct.
Let's talk about internships. I've had about 5 or 6 people message me about internships, how a company can employ interns, what sort of part of the labour law is covered, what sort of contract they need to have for interns, if they need to have a contract. What would that look like?
Okay, so interns are not at this point in time, with the information I have, not covered under the labour law as far as I'm aware, okay? But interns can work, students can work, however, they need to be on a local student visa, okay, so physically be registered in the country as a student, or be on the dependent visa of their legal guardian in the UAE. If you want someone to come as an intern who is not a resident in the UAE, you need to apply for a visa for them, and a residency visa. So you would need to process a basic employment contract with whatever terms and conditions you want to put in it, the same way as you would for any other employee, okay? And in terms of benefits and allowances, if it is a, for the majority of those who are on local, because you don't actually register them with the Ministry of Human Resources at this point in time, there is no requirement to pay end of service benefits or annual leave or anything like this. You just need the visa documents and an NOC, either from the sponsor, being the university, for example, or from the legal guardian, okay? Other than that, if it is a normal visa, then you would, sort of work permit, then you would go through the normal process and pay accordingly for that one.
Okay, super. So many questions, and they're coming in, and people are DMing me. You're popular today, Sarah. Okay, this has been asked about 5 times as well. People are saying, if an employee is working in another company, so basically they're working for 2 companies, how do you calculate the end of service gratuity?
Why? Okay, so you are employer number 1, and that person is working for you full-time and as under employer number 1. Your end of service is calculated according to the law. If that person works for 2 companies, they get gratuity according to their employment with each company individually. There's no overlap. But we do need to wait to understand if it's part-time as opposed to full-time, how that is calculated.
Okay. Can you go into detail a bit, because we had a number of questions asking about specific free zones, and that's not really your area of specialization, but maybe if you could clarify why some free zones might have extras added into the labour law that companies need to be aware of.
So, for example, DIFC, because it's Dubai International Financial Centre, they are set up for a specific type of business. So, for example, Jebel Ali Free Zone has a specific types of businesses within them. DMCC has specific types of businesses set up within them. So it is very much based around the type of business and industry on those, and I'm giving those as examples within Dubai because that's what I'm familiar with, but within those free zones, and that is why there are those specifications within them. And I think it is from the governing bodies of the free zones as a way to encourage investment and companies to open businesses within that area. And it means that, for example, for all financial companies that open under DIFC, then they all have to follow the same rules as financial companies, if you see what I mean. It just gives a bit more standardization in that regard.
Okay. Okay, we're almost at the end here. People working online for the UAE from outside the UAE, is a work permit required in the UAE?
That's a tricky question. Not to the best of my knowledge, providing they're employed by a company legally in whichever country that they're in, if that makes sense. So if you were in the UK, remotely working for I'll give an example, remotely working for the head office of a corporate HR, a corporate company over here, you would have a legal contract of employment in the UK and would be paid through the UK. The only time that you would need to have essentially approval to work in the UAE is if you were paid to work in the UAE and paid in the UAE, I believe.
Okay. We have one other question that's just popped up about interns, and interns are super popular with micro businesses, especially when they're growing their business. And we've had one question that says, can a person be an intern and be fully employed by another employer? So for example, they already have a working visa, but maybe let's say they have one job, but they've decided that they want to change their careers and they want to work as an intern, maybe over the weekends or in the evenings for another company without pay. Is that allowed?
Providing you can get an NOC documentation from the sponsor of the original visa, I don't see that that would be an issue. But I would recommend that that NOC needs to be in place.
Okay, so if you're hiring an intern, you definitely need to get the NOCs.
Yeah.
Okay.
Yeah. If it's a company as opposed to an individual, I would look for an NOC from that company, maybe a copy of the trade license, and then you've got all of the visa details and work permit details in any case. So,
okay, super. Can we talk about freelancers and using freelancers? So one, as a small business, if you hire freelancers to do work for your business, what needs to be in place for that? And then also as well, so I want to look on both sides of the coin here, that also people who want to work as freelancers, what things that they need to consider as well, especially with the new regulations.
Sure. So quite often people who are on dependent visas or students or others, visit visas, consider themselves to be able to work as a freelancer, which is not the truth of the matter. In order to work and I'll use myself as an example, I am technically a freelancer because I have my own business, but I work for multiple other businesses, and I do 4 hours with this one, 6 hours with that one, whatever it might be, or 1 month or 1 year or whatever. I still need to be legally allowed to work in the UAE in order to do that. So I have an e-trader license, I have a trade license, I have set up my business. It is a legal business and I invoice people under that business. There are companies set up where individuals can get a work permit and visa as a freelancer under the auspices of a freelance business, if that makes sense. So you can do it that way. But if you are employing freelancers, you don't have a responsibility to provide approval for work, but you need to ensure that they are approved to work, if that makes sense. Because if they're not, you are still breaking the law, if that makes sense.
So let's talk about what you need to, I know the answer to this, but I want to hear from you so it's clear to people what sort of due diligence as a business do you need to do to make sure that the freelancers that you're employing are legally allowed to be working as a freelancer for your business?
So you need to make sure and ask for either a copy of a trade license that they have. It can be an e-trade license, it can be a free zone license, whatever it is for the business that they're talking about, or they need to provide you with a copy of their visa and or labor card as an employee of a company that is freelancing. Usually if they're under a freelancing company, they would have to be paid via invoice through that company, if you see what I mean.
Yeah.
So you wouldn't get an invoice from Joe Blogs, you would get an invoice from Jobs at Joe Blogs, which is the parent company, and pay them, and then Jobs at would pay your employee or freelancer. So checking for trade licenses and copies of visas and whatnot.
And it's really important as a micro business or a small business to make sure that you do that due diligence and that you actually part of it. And we're going to be doing other workshops on this where we're going to talk about systems and processes to have in place as a small business, but to actually have a file where you keep copies of those. And you also know when their documents expire, so you can have updated copies of that as well.
Yeah, because hiring people illegally is very expensive. If you get found out, the fines go into hundreds of thousands of dirhams.
Yeah.
And that's an expensive mistake.
I'm going to put a hard stop on this in a second because I know everybody has other things that they need to do, especially you, Sarah, as well. But I'm going to go through a couple of other ones that are relevant for everyone. One, overtime information. They want to know is overtime now applicable for all staff regardless of level and seniority?
Technically, yes. So according to, and I'm going to find excuse me while I dig through my copies of things here to find the exact wording here. Technically, yes, overtime is for all employees, and it's anything over 48 hours or 144 hours in 3 weeks, okay? There is no exemption within the law at this point in time for specific level categories of workers, if you see what I mean. Article 20 specifically says, and this again is what I've been referring to throughout, the executive regulation of this decree determines the categories of workers that may be exempted from the provisions set forth regarding working hours. This document of executive regulations has not yet been published or shared with anyone. So once that comes out, there may be more clarity, but at this point in time, overtime is applicable for everybody.
Fantastic. Okay, last question. I'm going to end it asking you a question about golden visas. You kind of touched on it before, but a lot of people who have been in the country for a while are now getting golden visas. How can an employer hire somebody with a golden visa? What sort of responsibilities does the golden visa person have to be able to do legal work for that company?
So my understanding of the golden visa is that it is literally a residency visa and a permit to live in the country for 10 years. Therefore, you need to apply for permission for that person to work for you. So you need to get a work permit and make the request for the contract and labour card, as you would do if you were employing somebody who's on a dependent visa through the Ministry of Human Resources, and have that, that official legal approval for that person to work.
Excellent. Okay. I think that we have answered, Sarah, pretty much every single question.
Fabulous.
And I think now is the time to put a stop to it. It was so good. If you could actually just do me one favor and flip over, there's one last slide at the very end as well, just for anybody who is, there's how you reach Sarah as well. Sarah there's her website, there's her email. You also saw as well, she's on LinkedIn. So please do reach out to Sarah. You're a fountain of knowledge. So thank you very much for sharing that as well. And you're getting lots of love, and everybody's saying thank you so much, Sarah. So thank you for putting together such an elaborate, detailed presentation, because it's really answered everybody's questions. Everybody who's asking about where the recording is, as always, if you've registered and because you are here, you have registered, that you will get an email with the link to the recording later. And Sarah, if we can just go to the last slide. If you are an Arabic speaker, on Monday next week, there's going to be a session on digital marketing with Huda Naji, who is the founder of Media, and she's going to go into detail on digital marketing. So if you're an Arabic speaker, please do sign up for that. UN Women and NAMA Women Advancement have already emailed you about that. But I would just like to say thank you, Sarah, on behalf of UN Women and NAMA Women Advancement. Thank you for spending the time with us today. You've spent over 2 hours going through this. So I'm really grateful for you sharing this knowledge with so many entrepreneurs. And thank you to UN Women and to NAMA, as always, who are just phenomenal in their support of business owners in the UAE as well. So I would like to thank them all for that. And thank you to everybody today as well who has been taking part and participating in today. And it's just so brilliant to see everybody today. And also as well, remember that you do have those links in the chat. Maya had put them in there before if you want to sign up for the accelerator, if you are a new business, or if you have friends that you think might benefit from that. And also to get yourself signed up for the UN Women Women's Business Directory, because it's here. UN Women are here and NAMA are here to really help you build and grow your businesses. So please do sign up for that as well, so they can support you further. So thank you, everybody. Thank you for your engagement, participation, and always we're just so much stronger when we come together and support each other. So thank you very much for today.
My pleasure. Thank you.